Your Honor, that may not work. It may have to stick with me.
I think you're gonna have to move her further back.
I think so. No, I'm gonna move over here.
Yeah, we're getting awful feedback. That's been my experience with
They have
in the
this-
same room.
Your Honor, we may have to sit on the same side. I'm going to get out of here.
I think if you can separate rooms, you may be able to do it.
I don't want you to sit in the room. I want you to sit here. And move around. That over there. All right, now you move. Two laptops. Because we got two laptops. She's gonna sit by me.
Okay, you're just gonna use one then?
We're gonna just use one, Your Honor.
Okay, all right. All right.
Can we stop the video until ours starts?
Pardon me?
May we stop the video until you call our case?
Talking about the YouTube?
Like this?
I can put you in the waiting room.
Okay.
Is that what you want?
No, that's fine. We just turn the video off
All right.
and we'll mute.
Oh, I see. You want to stop your video. I understand now.
No,
Yeah,
that's good. We're gonna mute so we don't interrupt.
Okay. All right, then, for the record, this is cause number CCL 20D162 in the matter of Courtney Marie Byers and Philip Benjamin Byers. Record will reflect that Ms. Byers appears in person pro se. Mr. Byers does not appear. However,
Your Honor, can you maybe mute Mr. Northam also? I think I'm getting some feedback from that.
I'm sorry.
Yes, I will.
Just some noise there.
All right.
Thank you.
Okay, he's muted. Okay. Let me check this file. Okay, the court takes notice of the file in this case, indicating that Philip Benjamin Byers was personally served with citation on January 13, 2021. There is no answer. The return has been on file more than 10 days. There is no answer on file in his behalf, nor does he appear here in person. Therefore, he does appear to be default. And Ms. Byers, are you prepared to offer testimony in support of your divorce?
Yes, Your Honor.
Will you raise your hand and be sworn, please?
Yes, sir.
Do you solemnly swear or affirm the testimony that you are about to give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may lower your hand and you may proceed with your testimony.
Your Honor, my name is Courtney Marie Byers, and I am the petitioner in the suit for divorce. I am presently married to Philip Benjamin Byers. At the time I filed for divorce, I was documentarily of Texas for the preceding 6-month period and a resident of this county for the proceed of a 90-day period. My spouse and I stopped living together as husband and wife on or about March 21st of 2019. My marriage to my spouse has become insupportable because of a discord of conflict of personalities that destroys the legitimate ends of the marriage relationship. There is no reasonable expectation for reconciliation. There were no children born or adopted during this marriage. We are not expecting any children at this time. I am requesting the following division of property and debts separated: his house on his business, all his situations, all of his debt taken care of. I believe this is fair and equitable division of the community property and debts. I am requesting my name be changed from Byers to my maiden name, Crow. I am not requesting a name change to avoid creditors or to avoid criminal prosecution. I have sent you a copy of my divorce decree, which bears my signature, and I respectfully ask the court to grant me a divorce and approve all provisions in the proposed final divorce decree.
All right, you did not have children with another man while married to your husband, is that correct?
No, Your Honor.
That is correct or it's not correct?
No, it is correct. We did not have any kids, and I did not have another one while married to him.
Okay. You've proposed, you have a proposed order, which I've reviewed, and according to your proposed order, you're asking that property at 219 East Maple Street in Bloomberg, Texas, was owned by your husband prior to the marriage, and you want it set aside to him. Is that correct?
Yes, Your Honor.
And also, that you had prior to the marriage an account 16216 in Atlanta, Texas. What kind of account is that?
I was deeded a home and 2 acres of land when my grandmother passed away. That was just deeded to me right before the divorce was able to get finalized and pushed through. He has nothing to do with it. It was completely deeded into my name when my grandmother passed away.
So was it deeded into your name before or after the marriage?
It was deeded after the marriage.
But it was a inheritance or a gift from your grandmother?
Yes, sir. It was an inheritance.
Okay. So when you have account number 16216, is that an address?
That's just the account number. The address was not given to me because the house is considered unlivable right now. When I tried to get the address from the tax office, that's the only thing they gave me was the account number.
So that account number is on the tax roll?
Yes, sir.
Okay. But can you give me a little better description of it? In other words, what highway or street is it on, that kind of thing?
Let me see. I might have something that's got it on here. One moment, please. It's outside going towards Huffines. I do know that. It's past Black Bayou Creek.
Okay. What highway is that? You don't know?
No, sir.
Okay.
I've only been out there a couple of times.
Well, do you own that property together with anyone else or just by yourself?
No, sir. It's just by myself.
Okay. And your husband is not claiming any part of that property as community property. Is that
No,
correct?
Your Honor, he is not.
Okay. All right. I'm going to grant the divorce. Court finds there are no children born or adopted from the marriage and none expected. The property of the parties is awarded to the party in possession of the same as set forth in the proposed order. including the two real estate properties recognized as the separate property of each party. Ms. Byers, I'm going to go ahead and sign your proposed decree, but if you ever try to do anything with that real estate, this is not going to be adequate to transfer title in the eyes of a title company or anyone else as far as that goes to you. You really need to get a better description of the property. That's what the law calls a meets and bounds description, where the property's been surveyed, or a lot and block or something like that, or at the very least, a real estate reference showing where it's recorded by volume and page in the county.
Okay.
Because your decree is only showing an account, and you don't even have that it's on the tax roll. So that's not going to be an adequate description. I would suggest that you, after I've signed this, that you propose a amended decree giving a better description of your property, so you will be able to do something with it in the future. Okay?
Yes, sir. I do believe that it has been surveyed, but the survey only had longitude and latitude as far as the land size, because it was 8 acres that was split into 2 acres per person. So,
Okay. All right. Well, whatever kind of better description you can get, I'm just simply telling you that's probably going to be a problem in the future.
yes, sir.
All right. All right. I'll sign your decree. Divorce is granted. You weren't asking for a change of name, or were you?
Yes, sir, I was.
Okay. You want that changed back to Courtney Marie Crow?
Yes, Your Honor.
Okay, that's granted also. All right, then you're excused. You're free to go. You can contact the clerk's office and get a copy of the court order after they have a chance to process it.
All right. Thank you so much. Thank you, Your Honor.
You're welcome. You can sign off.
Bye.
Okay. Let me see if I can get everyone back. Ms. Lucky, have you solved your technical problems, you think? Uh-oh, I can't hear you. You're muted.
We're going to sit in front of the same laptop.
Okay. Mr. Northam, you can still hear me and see me okay?
Yes, sir.
All right. Let me ask you, Mr. Northam, you're not represented by an attorney. Are you representing
No, sir.
yourself? Are you representing yourself in this case?
God dang it. Hang on. I was trying to turn up the volume. Yes, sir. I guess so.
Okay. Do you understand what the petitioner is asking for in the case?
Yes, sir.
A protective order?
Yes, sir.
Are you opposed to the court issuing a protective order, or are you in agreement with that?
It's fine. I ain't gonna mess with her, but it's fine.
Okay.
Whatever you think, Judge.
So you agree with it?
Yeah, sure.
All right. Well, let me, it's all right for the parties to agree on a protective order. We don't have to go through all of the testimony. However, we can go through all the testimony if necessary. But I want to make sure you understand what you're agreeing to. So I'm going to ask Ms. Lucky to state to the court what she is proposing in terms of a court order. And I want you to listen carefully to that. And then after she finishes, you can tell me if you agree or disagree. Do you understand?
Judge,
I can't
can I ask
see.
you how you turn up the volume on this? Because I can barely hear you.
I don't know. There's different computers, different cell phones, and so forth.
I'll just do the best I can, I guess.
Well, I've got a microphone on, so you should be able to
Yes,
hear
sir.
me. It's on your end and not mine. Okay. Did you hear what I said, Mr. North?
Yes, sir.
All right.
I got it. There's a button at the top.
All right. Ms. Lucky, you may proceed.
Thank you, Your Honor. My client, Shauna Russell, is asking you to issue a protective order. And in that protective order, can everyone hear me?
Yes,
In that protective order, she's asking that you prohibit Chance Northam from committing family violence and from taking any actions that could cause physical or emotional harm to her or her family, to prohibit Chance Northam from doing any act that is intended to result in physical harm, bodily injury, assault, or sexual assault against Shauna Northam, to prohibit Chance Northam from doing any act that is a threat that reasonably places Shauna Russell in fear of imminent physical harm, bodily injury, assault, or sexual assault, to prohibit Chance Northam from communicating directly with Shauna Russell in a threatening or harassing manner, to prohibit Chance Northam from communicating a threat through any person to Shauna Russell, to prohibit Chance Northam from communicating in any manner with Shauna Russell except through her attorney, to prohibit Chance Northam from engaging in conduct directed specifically towards Shauna Russell, including following Shauna Russell, that is likely to harass, annoy, alarm, abuse, torment, or embarrass Shauna Russell, to prohibit Chance Northam from going to or near or within 1,000 feet of any location where Shauna Russell is known by Chance Northam to be, and to further prohibit him from remaining within 1,000 feet after he becomes aware that Shauna Northam is in that location, to prohibit Chance Northam from going to or near the residence or place of employment or business of Shauna Russell, specifically to prohibit Chance Northam from going to or near Shauna Russell's residence at 26 County Road 2860 in East Springs, and to prohibit him from going to or near the Beehive Salon at 301 West 3rd Street in East Springs, Cass County, Texas, and to specifically maintain 1,000 feet from those locations.
okay. Did you hear that, Mr. Northam?
That's fine.
Are you in agreement with an agreed order being entered by the court in that regard?
Yes, sir.
Okay,
Your Honor, Ms. Russell is also asking the court to award her attorney's fees of $1,250.
okay.
Mhm.
Do you agree with that, Mr. Northam?
Really, I ain't the one doing this.
That's not what I asked. Do you agree with it or
No, sir.
not?
No, sir.
Okay. All right.
I'll pay half of it.
How much you asking for, Ms. Lucky?
$1,250, Your Honor. That includes $375 for service. There were 3 citations served on Mr. Northam. And it also includes the filing fees, Your Honor.
Including the filing fee?
Yes, sir, that's everything. Court costs, service, attorney's fees.
Can you break it out?
Yes, I can see what the filing fees were. Let me find my- No, Your Honor, I don't have the e-file that shows how much the filing fees were. If you'll give me a moment, I can have, oh, here it is. Okay, the filing fees for the protective order application were $289.38. the service of 3 citations. There was a temporary restraining order, a notice of application, and a notice to show cause. That was $375.
Okay.
And so
I'd have to hear
that
some,
totals $664, and the remainder is attorney's fees.
so you have a 600 odd or so in attorney's fees.
Yes, sir. I'm adding right now, subtracting 6. 14's 8. That leaves $586 for attorney's fees. I believe if my math is correct.
Okay. Well, Mr. Northam is not in agreement with that, so I'd either need to receive evidence in the case.
Is it just to pay the attorney fees, the 582 or whatever?
There's 280, 289, is that what it was, 38? About 289 in filing fees, 375 for service fees. That's where the papers were served. And then she's asking for the difference in attorney's fees, making a total of
Okay, so
$1250.
like I said, I'll pay half of it.
You agree to that, Ms. Lucky?
What was the amount?
He offered to pay half of it. That's his compromise.
Miss Russell will agree for him to pay half.
Okay, half of 1250 is 625, I believe.
Yes, sir.
So you agree with that, Mr. Northam?
Yes, sir.
Okay. So Mr. Northam would be ordered to pay 625 as his portion of the court cost and attorney's fees incurred in the case. Is that agreeable, Ms. Lucky?
Yes, Your Honor. And Your Honor, Miss Russell has pointed out that in the protective order I e-filed to you.
Hang on just a second. Let me see if I can cut off that second. All right, I may lose you. You may have to check back in,
Okay,
but I'm going to cut off that second computer.
okay.
All
I'm
right.
still here.
No, that didn't get rid of the echo, so there is
I'm
an
gonna
echo.
go. If you'll give me 1 minute, I'll go hit leave meeting on the other computer.
Now, I've already removed it. You don't have to do that.
It's in the other room.
No, I've
Sure.
removed it.
So that's not me I'm hearing. Your Honor, in the final protective order that I e-filed,
Yes.
on page 2 of the order, Ms. Russell has pointed out to me that I have put 301 West Third for the salon. And
What
it
was
is
that? 301 what?
West 3rd Street,
Okay.
and it's actually 101. Do I need to submit a corrected order, or can you do that with pen and ink?
I can do it with pen and ink if that's the only correction.
Yes, sir. And that's on page 2 toward the bottom.
Okay.
That's the only place that address is in the order.
All right. Then you'll need to get a copy of the court order to Mr. Northam after I sign it. Mr. Northam, what's the best way to get you a copy of the court order?
I guess just mail it to me.
Just mail it. Do you
Yes,
have
sir.
his current mailing address, Ms. Lucky?
Is it 301 Houston Street?
305.
305. And you get mail at that address?
Yes, ma'am. It's 305 West Houston.
West Houston, in Dangerfield.
Yes, ma'am.
I will mail him a copy, Your Honor.
Okay. Mr. Northern, when you get it, even though this is agreed, it's still a court order.
Yes, sir.
So you'll need to read over it carefully and make sure you don't violate any of its provisions, or we'll wind up back in court. Okay?
Yes.
All right. All right, then I'll show the matter as an agreed order to be entered by the court based upon the testimony of both parties, together with an agreement regarding payment of $625 in attorney's fees and court costs. Anything further?
Not from us, Your Honor.
All right, then the parties and counsel are excused. Y'all may sign off.
All right. Appreciate it.
Thank you.
Okay, I think that's everybody but us. Chickens.
I think so. Yeah, that was that guy.